With regards to Najib Razak's application for leave to proceed with judicial review action on the issue of the Titah addendum, it was heard on the 17th of April 2024, and upon hearing arguments from both parties, the Honourable Court of Kuala Lumpur High Court had deferred decision to be delivered on the 5th of June. Question number 1 is, what are the issues for the court to determine at the leave stage? Now, on this issue, the only consideration for the court is whether there was possibility of there being in existence a Titah addendum for which Najib is claiming his right for the government and the authorities to follow the contents of the Titah addendum. If the Honourable Court is of the opinion it is possible there was in existence the Titah addendum, then in law, under judicial review, there was a possibility of there being a decision to be reviewed. Hence, leave can be granted. But if the court is of the opinion, regardless of what is contained in the affidavits filed for and on behalf of Najib Razak, there appears to be no or not in existence the Titah addendum, then the answer or the decision would be to dismiss the application. However, first and foremost, Zahid Hamidi had affirmed an affidavit on 9th of April before the hearing of the application, in which Zahid says that he corroborates the fact of the existence of the Titah addendum by his averment that he had sight of a copy of it in the telephone records shown to him by Tengku Zafrul. Court can make the finding that that may be sufficient to show there was in existence a Titah addendum for which leave can be granted, and thereafter the court would consider whether, upon hearing the substantive argument, whether the Titah addendum is valid to be complied with or otherwise. But in the interim, after the hearing on 17th of April, there have been two developments. The first was that Tengku Zafrul had filed an application to seek leave to intervene in the judicial review application for the sole purpose of putting in an affidavit which, in his words, through his press statement, were just to clarify certain factual issues in Zahid Hamidi's case. But Zafrul also made it very clear that he is not taking side of either party, whether Najib Razak or the government of Malaysia, on the issue of the effect of Titah addendum. However, the application was heard by the same Kuala Lumpur High Court, and the court had dismissed the application to allow Zafrul to intervene. Why? In law is because at this stage there was not in existence a matter before the court yet. It is only at the stage of whether leave is to be granted. If leave is granted, only then there will be a proper judicial review application for any party to apply to intervene. So, highly possible that the reason why the application for Tengku Zafrul was dismissed is because there is not in existence as yet a proper judicial review, substantive hearing before the court to allow anyone to intervene. However, of course, the court has not issued, from records thus far, any grounds of judgment. But this would be the normal position of an application to intervene and the grounds in order to allow any party to intervene. Now, the second issue which transpired was the filing of another affidavit by Najib Razak an affidavit which was affirmed by the Menteri Besar of Pahang. And this affidavit was filed after the hearing but before the decision. So that brings up an issue for the determination of the court. If the court finds that that particular affidavit does also support what Zahid Hamidi said and what Najib is seeking for, then he may, in order to determine the decision, call for both parties to argue the position of law, whether he is at liberty to admit and consider that affidavit before making his decision. If that happens, then the logical flow of event is there will be no decision yet on the 5th of June, where parties will have to argue and make their points in relation to in support of accepting the affidavit or in opposing the affidavit. However, if the court had already determined, as stated earlier, that there is a possibility from Zahid's affidavit that there is in existence the titah addendum, and therefore the Pahang Menteri Besar's affidavit is not necessarily required because he has already made a finding of the possibility of the existence which need not have any further corroboration, and therefore he would, his lordship, the Kuala Lumpur High Court judge, would be in a position to deliver a decision which would be to allow the application for leave.